So this issue is regarding Zoom use. So concern is risk for 1, litigation resulting in technology failure. 2, the requirement to redo any meetings wherein a technology mishap occurs. 3, a notation by the Idaho Association of Counties identified a risk related to technology failure and a risk for the need to re-agendize the item. So those were the 3 issues with using Zoom. So I'm going to give a brief history. History, 1, Bonner County has 0 litigation suits filed resulting from a Zoom technology failure. 2, Bonner County has redone a total of 0 hearings since allowing the public access to county business via Zoom over the past 2 years approximately. 3, Bonner County employees continue to have a need for Zoom. For example, planning and zoning uses Zoom to present to the board. Recommendations from Commissioner Williams. So I recommended that we review a disclaimer, for which I wrote the disclaimer and sent it for legal for review. So I'm going to read you the disclaimer and the legal response that I received. Disclaimer. Use of the Zoom link is not intended as a substitute for in-person or written participation in the proceedings of county business. It is possible to have technology issues with the Zoom link to include, but not limited to, difficulty hearing and being heard. If you have information to communicate to the county, please come in person or send your information in writing. The county cannot assure that the information will be received via Zoom. Use of Zoom is at the risk of the user. Technology failure will not result in the county re-agendizing and or accepting post-deadline information on any given item or issue. In-person attendance is recommended. I sent this to Bill Wilson and his response was, that is a very well-written and would definitely reduce the risk. I brought up with using Zoom. As I said in exec session earlier this week, if you guys chose to go in this direction, we could do our best to work around the risk. However, it is impossible to know for certain what a court would do when faced with the issue. So I still believe that the safest thing to do is to stop using Zoom entirely. The point that I'm going to focus on is that the disclaimer was identified to reduce the risk. So, my rationale, Title I County Operations, Chapter 1, 130. The Board of County Commissioners adopts a policy of non-discrimination on the basis of disability. Subsection B, it is this policy of the county that with reasonable accommodation, all programs and activities shall be accessible to and usable by qualified persons with disabilities. I want to give a definition of accommodation which says a convenient arrangement, a settlement, a compromise. Title I, Chapter 2, 1-200. The chapter is enacted for the purpose of establishing a regular meeting schedule for Bonner County Board of Commissioners in order that the board activities can be carried out with greater public participation and awareness, Ordinance 192. So I'm going to define these terms because it's part of the foundation of my argument. Greater is of an extent, amount, or intensity considerably above normal or average. Participation, the action of taking part in something. And I'm going to stress the word action. Awareness, knowledge, or perception. As a public entity, we will never be able to remove all the risk. However, we must use risk mitigation tools and strategies whenever possible to reduce the risks associated with decisions. Idaho Association of Counties has identified a risk associated with the use of Zoom. Above is a disclaimer that, based on the opinion from legal, does in fact reduce the risks associated with using Zoom. It clearly states that the use of Zoom is at the risk of the user and that Zoom is not a replacement for in-person or written participation in a given activity. The argument to discontinue Zoom solely based on an inherent risk that exists with a public entity is a specious argument. When one reviews the code and the ordinance of the state of Idaho and Bonner County, it is clear that the law requires that we're using the imminent nature, which we find when we're looking at executive session as an example. It doesn't say we can go into executive session if we fear it, it has to be imminent. I also want to stress that YouTube actually serves to disenfranchise the public because the requirement is greater participation. Using YouTube actually limits participation, therefore we're going the wrong direction of what our current policy says. In order to participate, it is an action. To sit and watch on YouTube is passive. So we need to review the risk, make a clear decision that it does in fact mitigate it, and then address the issues moving forward. We don't make a decision. To argue the case in the manner that we are, it doesn't make sense. We have a greater risk with all of you coming to this building than using Zoom. That is a greater inherent risk. And so my argument is very clearly documented. It does reduce the risk. And I actually am going to argue that if we fail to reinstate Zoom today, because that's what's on the agenda, we are disenfranchising disabled people that we have an obligation to accommodate, and we are also not following our own code to increase greater participation in public business. So that is the argument that I'm making for reinstatement of Zoom, and it has already gone through legal as a disclaimer that does in fact reduce the risks associated. So I move that we accept the disclaimer and reinstate Zoom today.
Do we have a second?
Mr. Chairman, I'd like to amend the motion. I would amend the motion to table until I hear directly from our legal counsel.
I just told you.
I appreciate that, Commissioner Williams. I would restate it. I would amend the motion and table this until I hear from our legal counsel. That is
Will you accept me emailing you his document?
That, before we can amend it, we have to hear the motion that was presented.
Yes, Mr. Chairman.
Do we want to amend your motion, Ms. Williams?
No.
Is there a second? Item dies. At this time, I will make a comment, and it may help clear up some stuff, okay? We had classes on this 2 weeks ago. Y'all paid for us to be trained on these things. This is a business meeting, not a public interaction, let's have a conversation meeting. We do not have to allow public comment. It's not required by state law. It is a business meeting, and yes, we are businessmen. You hired us to handle the county business. Okay.
You're commissioners.
Nobody has a given right to comment during the business meeting because it is business. This has been granted by the previous board so that we could interact. And it's kind of like a forestry service road where it's open to everybody. It's our land. We pay for it. But because a couple of bad actors with motorcycles go in and tear up the hillsides, the Forestry Service closes the roads because of some bad actors, and everybody pays the price. I would hope that that never occurs in our business meeting, and we continue to allow public comment. But the public comments will stay on track with the items. They won't get no rabbit trails, no accusations, no derogatory, but things that are productive and positive. And I'd like to see that continue, but by no means do we have to continue that.
Mr.
So,
Chairman?
by law, we do not have to grant that. But I think it's unanimous with the three of us that we would like to continue that.
Mr.
Am I
Chairman?
correct in that assumption?
Mr. Chairman, I have a request.
Yes, ma'am?
Can we take a 5-minute break for Commission Ahmad to review the email from Bill Wilson and Rule of Time so that we can make a decision on this item for the public?
No, that, we're already past that motion, so
Mr. Chairman.
no more public
public
comment.
comment on that issue?
We're going on to the next item.
As an ADA person, I urge you to reconsider very, very cautiously the decisions you're making. ADA and religion are the two strongest fundamental challenges you will lose in a courtroom. And if you all agree to the decision to bring Zoom back up with the protections, especially the ones Jim Kelly mentioned, you are covered. A complete board vote that's unanimous with consideration from legal almost absolves you. If you're considering me as the litigious person that made a comment relative to Zoom, you're highly misplaced, because I have not filed a lawsuit in a single courtroom in this
Nobody
county.
said you did?
Or this state.
Okay, Mr. Rose,
But I'm just
you will
telling you.
control yourself.
I'm very well controlled, even though I'm, how do we say, a little frustrated with this activity at the front.
Thank you.
I'm still in control, and I'm trying to give you constructive advice, but you don't want to listen. That's on you.
Yeah, I think that listening goes both ways, Mr. Rhodes, but thank you.
Is there no public comment on that issue?
Mr. Chairman, I would call for the order of the day, Mr. Chairman, to return us to the agenda so that we can continue the work of Bonner County.
Yes, we may.
Mr.
Okay.
Chairman, you didn't allow the community public comment on the issue of Zoom, or are you
Well,
denying
the
that?
motion died, so you never got a
The
second.
amendment died. There was no question about the original motion. Just so you understand what you didn't do
She
right.
made the motion, there was no second.
The
Therefore,
amendment was up.
therefore,
And there
the
was no
subject
second to
is
the
dead
amendment.
at
You go
that
back to the
point,
motion.
and there is no more
We
public
didn't say no
comment.
second.
Mr. Rhodes, you may leave. Now,
Oh, yeah,
now.
okay. Bye-bye. Bye-bye.
Don't force my hand.
Isn't that what you want to do? You want to control that too?